So if you walk into a hostage situation and there are 4 hostages, you're not successful if you take out 2, right? You have to bring out all 4. So what I'm gonna be sharing with you hopefully will benefit not just you and your practice, but also your life. So let's begin. The first one very quickly is that the presentation is obviously educational. I do not represent you. Yes, I'm on city council here in the city of Arcadia, but I don't represent city council. And it's good that you hear that because the perspective as an attorney may be very different than myself as a council member. So everything I'm going to be talking about today is going to come from my views as an attorney and not my views on city council. So it's going to be a little bit different. And yes, I do real estate business and labor compliance.
And that's a full disclosure, right?
Yeah, that's full disclosure, yeah. So there are 2 main types of laws, super easy, right? You have criminal on one side and you have civil on the other. Now, why do I share this with you? I share this with you because this up here is the first year of law school. So you spend 1 whole year figuring out what non-criminal cases are about. Why is that important to you? It's important to you because if you see an attorney, your attorney is going to have the same type of thinking. And so it's very important for you to know what they're thinking. So on one side of a non-criminal case, there are civil cases. And the civil cases have contracts and torts. Now, what is a tort? A tort is just a non-contract civil case. That's all it is. So ignoring the contract for now, let's take a look at torts. A non-contract civil case is called a tort. It's split up into 3. One is an intentional tort. The second is negligence. The third is strict liability. So I'm going to give you examples. An intentional tort. An intentional tort means that you have to have the intention as a defendant. And if you have that intention, you lose. So let's just pretend you're at a bar and you punch somebody in the face and you get sued. You're going to get sued for battery. One of the elements of battery is the intention to hit somebody. That's one of the elements. It's an unlawful touching of another person, the intentional unlawful touching. But let's say that you can show that you had a stroke and your arm just went out like that, right? Who would lose? The plaintiff would lose. Why? Because battery requires the intentional unlawful touching of another. So when you have a stroke on an intentional tort, for example, the defendant wins. What's negligence? Negligence is society has set a standard and you fall below that standard. It does not require intention. Let's say that you're in a car, you're driving, and the person in the front stops at the red light. Boom, you hit them. Who loses? The person in the back. The person in the front doesn't have to prove that you had the intention. Society has said that if 2 cars are driving, the person in the back has to be more careful. That's all society says. And that's the standard. You fell below the standard and you hit the person in the front. That's negligence. What is strict liability? Really cute dog, right? First thing I did when I saw the dog, I grabbed the dog because I have 2 dogs, right? What about if the dog bit me? The dog's owner loses. Why? Because the law says that if it happens, you lose. That's all it requires. Intentional tort, negligence, strict liability, that is very important because a non-contract claim requires either intention, duty, or strict liability. Contract claims are just real estate. It's all based on terms. And again, I share this with you because of the fact that when you go to an attorney, that's what they're thinking. Is this a contract claim or is this a non-contract claim? If it's a non-contract claim, it's a tort. Is the law require you to have intention, or is it a duty breach, or is it just strict liability? That's all you have to learn, okay? It has nothing really to do with what we're learning today, but it provides you the context of the entire body of non-criminal cases. So let's go over some of the cases that I've seen during COVID. And I'm just going to share with you basic laws so that you can become more comfortable. One of them is I can't read English. I can't read English and I signed a document where I cannot read English. Well, in California, it basically said that consent is not mutual unless the parties all agree upon the same thing. However, the law is very clear. If you sign something and it's not in English, if you sign something and it's in English, the law is going to bind you to those terms unless you can show that you were defrauded. Why do I share that with you? Because in the real estate context, we get that all the time. I didn't know that I removed the contingencies. I couldn't read it. The law doesn't help you when you say that, right? Now, if you were defrauded into doing it, that's a different issue. But if you're just taking the defense of, I can't read English, that in and of itself is not a defense to overturn a contract. Second one, attorney-client privilege. Now, this is something that I think is very serious because in the United States, the only relationship that is confidential, in my opinion, is going to be the confidence between an attorney and a client. And I share that with you because of the fact that many, many clients feel that they don't need to tell their attorney everything, but they'll tell you everything, which includes, yeah, there's mold all over the wall and I just repainted it. And they just assume that the real estate agent is going to hide it. And so this is very important for you to know because in a lot of real estate litigation cases, the truth really comes out through the agent. Because if you're not honest about what happened, you could be liable, you could have licensing issues. And so in situations like this, I always recommend that you remind your client that there is no confidentiality. Okay. Oral promises, just to let you know, oral promises are not only hard to prove, but in the real estate context, they are always excluded. Why? Because you sign contracts that say things like this. This agreement, together with the other loan documents as written, represent the final agreement between agent, lender, borrowers. It may not be contradicted by evidence of prior, contemporaneous, or subsequent oral agreements of the parties. There are no unwritten oral agreements among agent, lenders, and borrowers. And I understand that I took this out from essentially a loan document, but I just want you to know this type of language in real estate is everywhere. So a lot of times the clients will say, he promised me to do something by WeChat, or there was a text message or an oral promise. But in real estate law, there are no oral promises. It just does not happen. Now, there is a problem because this clause in terms of integration, this is called the integration clause. It's everywhere. So the problem is, and I don't know if I addressed it elsewhere, but if you have an integration clause in terms of your purchase and sale and an integration clause in terms of your escrow agreements, when they conflict, then the attorneys have to fight which one was signed last. So make sure that your purchase and sale is consistent with your escrow documentation because there is a lot of overlap. And sometimes what agents do is they focus only on the purchase and sale. They're like, oh, escrow is escrow. That's not, I don't have to worry about escrow. I don't have to worry about title. That's not my jurisdiction, which is true. But the problem is when there's a real estate lawsuit, there's a lot of overlapping terms that people fight about. Okay, yes.
Over the years, I've had a few escrow officers mention that if there's a conflict, that everything refers back to the purchase agreement terms. Is that appropriate? And I had that understanding because they did say there could be a conflict, but if there was, it reverts back to the purchase contract.
So what was your name, sir?
Mike.
What was your name? Mike?
Mine.
So Mike's very intelligent, right? Is that he's essentially saying, look, I'm not an attorney, but I have to spend more time to make sure these terms are correct. And if there is a conflict, because now an attorney is saying there is conflict all the time in real estate contracts, and it reverts back to one specific contract. And yes, that doesn't mean you're doing legal work. You're essentially making sure that if there is a conflict, that there is one document that you can go to and that document controls. I just want to warn you in terms of the prior PowerPoint, is that what I consistently see is individuals not like Mike that aren't taking the time, that are basically doing one thing, close, 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 right? I hear that all the time. Close, close, they like cheer, right? But the problem is, yeah, the 99% that close, that's great. But then you have a 1% that doesn't read English, that essentially has contradictions. And I want to address these lawsuits with you for you just to have an understanding of this happened a lot during COVID. And one of them is which contract controls. And so Mike is very intelligent because he says, look, I've realized that. So what I do is in case there is a conflict, this document is going to be the one. Okay?
So a lot of buyers, they are not interested in English from China.
Yes.
So what do you suggest? They
Well-
hire a lawyer to read over the contract.
Yeah, okay, so look, of course, any attorney is gonna say it's better to put the responsibility on the attorney, right? What I've been doing with my clients, because I don't read and write Chinese, right? I speak Mandarin, but I came here when I was 2. So the reality is, apart from legal terms, I speak like a 6-year-old kid. And so what I've been doing is I've been translating documents. I've been translating my emails using ChatGPT. I don't know how accurate it is, but I've been doing it just to make sure that the client is able to understand. Because one of the things that the clients do when there's a dispute, they don't think anybody's at fault except for you, right? You were the person, right? And because of that, I've encouraged the agents to do as much as possible to get as much translation out to the clients. Because I understand that, of course, you could say, go find an attorney. You should spend $3,000 and hire a certified Mandarin translator to translate it. Those are hard conversations to have. Of course, from an attorney standpoint, I could always say, oh, you should do that. But I think I'm very realistic that it's not easy to do that. And so as an attorney, that's what I've been doing. So I'm just letting you know from my practice, I'm just literally all of my emails, if I know their first language is in Chinese, I'll write my email, obviously in English. I copy and paste it into ChatGPT. In the front of it, I say, please write the following in traditional Chinese or simplified Chinese, and I just type it. And I've translated 25 pages of a complaint, where I actually did that recently. And the client was really happy, right? And so that's my recommendation. I don't know if I answered your question. Did I answer your question? I hate it when attorneys don't answer questions. No, because that happens all the time. Okay, so if I did,
Maybe not the way she wanted to hear it, but you answered the question.
yeah, if I do,
I agree what you say, but sometimes the translation.
It's
from
off.
English to Chinese is still not really.
yeah, so they're gonna come to you. Yeah, so that actually happened where I have a lawsuit. It's a really good lawsuit on plaintiff's side. It's a breach of contract, fiduciary fraud. I wrote the complaint, and basically my client came back to me and said, yeah, everything's right except for this.
Yeah.
But I realized it was translated wrong, because what I then did is I had him read it to me. Well, actually, you could have like Google Translate talk to you, and I realized that they just reversed it.
Yeah.
So if there's a mistake, right, hopefully the client will come to you. Again, this is not perfect. I'm just telling you what I'm doing in my practice. Okay. There's a lot of PowerPoint. If you have a question, please write it down. I promise I'll answer it, because I don't like people that don't answer questions. Okay,
Yeah, So please write them down, so that way he can get through his slides, and he can try and cover all your questions.
Okay. So this is a big thing, as is purchase and sales. This has become very common, right? Even in a market that's not good, every seller wants to sell as is. But the law is not what you think. Just because you sell something as is, you are still responsible for defects that you know but do not disclose. So I'm going to repeat that, because this is kind of surprising for a lot of people. All right. The as is clause is typically, it says you accept everything, every defect you can find, water damage, this damage, that damage, right? You let go of your firstborn and all of that stuff, and the person signs off on it. And you as the seller, you're like, oh, great. And the agent listening is like, great. And they get sued and you lose. Why do you lose? The law basically says that if there is a hidden defect and the agent knows about it or the seller knows about it, and they hide it and it's not easily found, you are still liable as the seller and possibly the agent when you sell as is. So the as is clause is not a get out of jail free card, right? But it does help, right? When there's an as is purchase and sale, when you really don't know. Now, people always ask me, right? How much should you disclose? And obviously an attorney is always going to say, disclose as much as you can. Particularly, obviously, this is an obvious statement, if the buyer really wants it, and yeah, you have a noisy neighbor, that's not going to reduce the price. If they really want it, they don't care what you write. And that's actually good. If the buyer really wants it, you should write everything you can think of, right? Dog barks. Amazon, you know Amazon's been delivering to my house at 5 a.m. in the morning? It's the scariest thing. Has that happened to you guys? No.
You're special.
No, that's probably a person that's gonna rob me. It's happened twice, right? Right? And so you could write on there, yeah, Amazon delivery guy comes at 5 a.m. in the morning, several times a month. I have no idea why. Buyer's still gonna buy it, right? But I have seen so many as is purchase and sales where the buyer ends up suing for a noisy neighbor, mold in the wall, right? They actually open it up and you could just tell it's just patched, right? And the seller knew about it. So please disclose as much as you can, even as is, even when it's as is. We went over this in terms of escrow instructions. Let me just see. Yeah, we already went over this in terms of conflict. In terms of title insurance, very easy thing just to remember, America is bigger than California, right? So ALTA, don't even matter what it means. ALTA stands for America, CLTA stands for California, always get ALTA, right? That's all you got to remember, right? Because they're going to give something to you, and many times people pick what's cheaper. ALTA is just a little bit more, very, very little. Now, if you are purchasing something and you have a specific thing in your head, right? One of the things that, this is unrelated, this is an insurance issue, is you really have to look at exclusions. And exclusions are big problems that occur all the time, all right? So this is one of the exclusions that we've seen, right? And one of them is violations of zoning, and that happens actually quite a bit. Sometimes I actually see this quite a lot where it says that there's a citation by the city, but it is not on title. Title insurance will not cover that, right? So if you feel that there's a problem with the property, every city that has a city government has a city manager and a building department. You should have the buyer go and check with them to make sure the intended use is allowed, to make sure that there are no citations or problems on the property. Because that actually has happened even in the city of Arcadia, right? Somebody has purchased a property and they're like, oh my God, I have so many citations, like, I'm not going to pay. And the city is now, somebody's got to pay, right? So this is very important, is that not just for residential purchases, but for commercial purchases and leases as well, have a meeting with the city manager. Sit down and make sure your intended use is allowed. Okay. You know, I woke up so early this morning, and I'm typically in bed by like 8:30 and 9 o'clock, but I am just not that excited today, a little bit tired. So I do apologize. I'm a little more excited than normal. Sorry. So,
We like excitement.
oh, okay. Well, all right. So another one is notary. People from overseas constantly think notary is from the court, and a notary is not from the court. So just because two people signed a contract doesn't necessarily mean that it is court certified. So this is just lawsuits that I've seen. It may not apply to you, but I just want to remind you of that. Elder abuse. Okay, I'm seeing a lot of lawsuits on elder abuse. Now, the real estate industry is all about specialization as well as the legal industry. Every industry is about specialization. There are a group of real estate agents in every office. They focus on elders. They focus on people that need to dump their property when they get old. They focus on different issues, but they all got to be a certain age, typically in their 70s. The problem with elder abuse is this. An elder can be able to overturn most of the transactions because the law basically just says you have to treat them reasonably. That's it. Just reasonable. So if you have 12 jury members that basically say, man, that's under market, that's okay. That's under market by like 200,000, 300,000. I wouldn't recommend that to the elder. You have to understand, they're not the real estate agent. They're just thinking that way, right? They're like, man, that's kind of cheap for that property. You could be liable because the elder is going to say that they don't understand. I understand earlier I talked about English, non-English, but in terms of California and elder abuse, the law is so broad that any person over the age of 65 can go to an attorney. And it seems like every time they sue, they always get damages. And I'm actually in an elder abuse case right now. So I can be able to tell you that it is so easy to get transactions overturned. So just be careful. Let me see. This one we've discussed, fault of agent. Letter of intent. Letter of intent is very important because so in Asia, arbitration's been around for 100 years. In the US, really only been around for about 20, 30 years. Letter of intents, very new overseas, but very, very old in America. And why is that important? Because people don't quite understand a letter of intent can be binding. So I'm going to repeat that. A letter of intent can be binding. Just because something says letter of intent, if it does not say that it is not binding, people can sue on that as a breach of contract. So it is very important, right? So a letter of intent can be both binding and non-binding. And there are a lot of people that are very smart that make sure it's ambiguous enough to make sure that it is a binding agreement. The word letter of intent is not a word that means it's not binding. So I'm going to repeat that because a lot of people say, oh, it's just an LOI. You hear LOI, LOI, everybody's talking about LOI. But the problem is an LOI, that word does not mean it's not binding. It needs to write in the letter of intent, this is a non-binding agreement. And here I share that there are many other types of letter of intents, right? So you need to explore the different letter of intents so you don't get caught. And this is something I think real estate agents, commercial guys are very good, but a lot of residential people don't quite understand that. So they step out into more of a quasi-commercial context and LOIs are everywhere. Binding, non-binding, hybrid. You know, there could be a LOI that says, this is a non-binding LOI. But if there's a contract, they must be these terms. Kind of like what Mike was saying earlier. And then you're stuck. You're like, well, but I thought it was non-binding. But yet if you have a contract, the non-binding LOI says, if you do have a contract, it must be based on these terms. So just be careful. Other things that I've seen, there are a lot of real estate contracts that say to get attorney fees, you have to mediate first. And you need to have good faith mediation. A lot of plaintiffs have forgotten to do that. They forget to have good faith mediation. They can't get their attorney fees back, right? Venue, this is very important. Venue basically means where is the case going to be litigated and what is the law that you're going to use. So you have a buyer that's in California, a seller that is in New York, a property that is in Texas, and the document was executed in Florida, right? When there's a dispute, where is it going to be litigated? What law are you going to use? So these are all things that are very important because if you're dealing with particularly foreigners, that is going to be an issue, right? Another one is foreign contracts, just to let you know, purchase and sale agreements can be in any language. Contracts can be in any language. Attorneys always say that it needs to be in English, right? But I just want you to know that having it in English is a requirement if you're going to file it in court. It needs to be translated by a certified translator, but the document is legal. The document is legal. All right. Who are the parties? I get this all the time. So you have to remember that in the United States, if you want somebody to have personal liability, you need to make sure that not only do they sign, but you write that they have personal liability. So if somebody signs on behalf of a company, they're not personally liable for the company unless there's fraud. You guys aren't that excited, neither am I. I'm so sorry. Arbitration, this has become really big as well. And we talked about an integration clause earlier. Okay. So now that we've talked about cases that I've seen and are still occurring, I'm going to talk about an area that I think is very important. And that is that clients are disorganized. Attorneys are more disorganized than their clients. Okay, I'm going to say that again.
I told you he was humble.
Yeah. Clients are inherently disorganized. Attorneys are more disorganized. We do not go to law school to organize documents. However, in the real estate context, it's all about documents. So I'm going to teach you how to be a better client so that you can help your attorney be a better attorney, right? Because the goal isn't to hire an attorney, don't like them, and rehire. It's to train your attorney to be a better attorney by being a better client. So how would you do this? The first thing is, before you see an attorney, summarize all of the issues on one page, right? Font 12, font 13. It's better to do font 13 or 14, right? Because attorneys are always tired. The second page, you're going to write what you want. So many times clients come to me, they tell me their case, totally disorganized. I'm already like 5 minutes later, I'm like, oh, man, I can't believe, how come my office like had this type of client come in? You know, I can't believe, you know, oh, but they paid me, so I have to sit half an hour. Okay, right? And then I say, what do you want? They're like, I don't know what I want. I'm here. And I'm like, but how do I know I can achieve your goal if you don't know what you want? So second page, tell the attorney what you want. The third page, write out every bad thing about what the other side is going to say about you. Be objective. There's so many times attorneys are going to come to you in the middle of the case. They're going to say, you got to lose their case. And you're going to be like, wait a minute. I hired you. Shouldn't you have told me I didn't have a good case? And the attorney's going to say, well, I didn't know about it. I just found that out in the middle of the case, right? How many times that, well, people don't like it when they hire attorneys, but that happens a lot. So what are you going to do with these 3 pages? You're going to email it to the attorney before you see them. You're going to email the attorney before you meet with them. And what is the attorney going to do? 1, the attorney may not read it. Good. When you meet the attorney, they're not prepared, not the attorney you want to use. Great. Second, the attorney may realize they're not specialized in that area, right? It may be a very unique situation the attorney just doesn't understand. They're going to refer you out to somebody that does this area of law. The third thing that they're going to do is they're going to read it, they're going to understand what you want, and they're going to understand the errors that the other side is going to say about you. And you're going to have a better meeting, right? Because typically you meet an attorney, it's about half an hour. I just want you to know within the first 5 minutes, the attorney has already made a decision. 1, they know your case. 2, they don't like you, they've already checked out. 5 minutes. 5 minutes. So why is that important to you? Is because people come to me all the time and they have these crazy stories, all of these emotions, nothing to do with the case. And I'm like, okay, you know what? I have half an hour, right? I'm always very timely. We started at, right, 2 o'clock. We got to be done at 2:30. I have another client. And then they get to the point at 2:28, right? And the attorney is checked out. And that's not good. So this is first step to hire a good attorney. If you can't be able to get what happened on one page, I don't necessarily know if the attorney is going to understand, because you have all of these emotions, 2-3 years, right? And you expect an attorney to understand it in half an hour. I'm telling you, the attorney's checked out in 5 minutes. Okay. Next one I want you to do is to photocopy all of your documents. How many times clients have come to me and they said they hired an attorney and the document, the biggest, most important document was never shown to the court? I'll tell you why. The attorney may have lost the document and too scared to tell you, right? It happens. It happens. How many times has a client said, Hey, did you get my email? Most important document. Did you get my email? Won't even tell you date and time. Did you get it? Most important document. What is the attorney on the phone going to say? Yeah, well, of course, right? So you have to understand that attorneys are people too. They did not go to law school for organization purposes. So I'm helping you have a better attorney. Photocopy all of your documents. Do not give the original document to the attorney unless they ask for it. Copies only. The third thing is going to blow your mind because when the attorney sees it, he's going to totally love you. What is it? It's an Excel spreadsheet. Every document that you have, you're going to spend the time. You're going to spend the time to organize the documents for the attorney. Document number 1, what is 1-1 to 1-12? There are a total of 12 pages. So on the bottom, it's called bait stamping. Super easy. I can have a class on it. It'll only take me 10 minutes to show you. You can add on the bottom of the page 12 documents, 1-1, 1-2, 1-3, 1-4, all the way to 1-12. Then you're going to name the document. You're going to name it, any name. Don't worry about it. The third category, you're going to say, what does it show? What does it show to you? The fourth one is, why is it important to you? Sometimes there's overlap, sometimes there isn't. And then you're going to do it for every document. Why is this important? Because when you call the attorney, you're not going to say, hey, did you get that document? You're going to say, can you please look at 1-11? And the attorney is going to flip to it, have your Excel spreadsheet, and they're going to say, yes, of course. 1-11 is what the terms are, right? And it's very important because these are the terms that you agreed to. Do you understand what I'm trying to help you guys do? I'm trying to get the human element out of your relationship, right? This is the problem that we have with attorneys, is that we expect attorneys to be totally organized, robotic. We expect them to be totally excited, and they're none of that. They're none of that, right? They go home just like you do, and they drink 3 glasses of red wine. And they wake up in the morning and they're like, man, I can only do this for another 10 years, right? And then they meet you and you're talking all these emotions when you could have sent them 3 pieces of paper a week in advance before the meeting to tell what the case is about, what you want, and what the other side's going to say. And then when you retain them, instead of saying, here you go. These are the documents. And you walk away, you organize it for the attorney. So then when you speak with the attorney, you're not speaking about concepts, you're speaking about numbers. And I understand attorneys aren't math people, but if the attorney can't be able to look at 2-3 on the bottom of a page and can't open up an Excel spreadsheet that says it's the email between the parties, it shows that they admitted that they were wrong. And he says that we don't have any correspondence. If he can't be able to, he or she can't read an Excel spreadsheet, then you've got real big problems, right? But I'm trying to help you avoid these problems. Okay, so let's talk about 2024 new laws. So 2024 new laws, there are several. Now, there are a lot. However, I think that these are going to be the most relevant for the real estate industry, okay, in 2024. The first one, a lot of people don't know, it's called a trespass letter. So what's a trespass letter? This law was already there. You can go to the police department, you can say, this property is abandoned. And if anybody's on that property, get rid of them. Remember the police used to come, they're like, oh, I can't get rid of anybody. I'm so sorry. And they're so frustrated. The reason why is they don't have a 602 letter. So the 602 letter, it's under Senate Bill 602, extends it from 30 days to 1 year. So you only got to go to the police department once a year.
Except for the sheriffs. A little different.
Are they?
Yeah.
Okay.
Special.
Okay. So I'm just letting you know that if you are managing property for people and the property is abandoned for whatever reason, go to your police station and just say, hey, look, can you give me information on 602 letters? Right? And they'll be like, oh yeah, if you write a letter, are you the owner? And you basically, yeah, I'm the owner, right? This property is abandoned, nobody's there. Then if you have homeless people, if you have somebody that decides to use it as an Airbnb randomly, they can just kick them out. No eviction required, right? Because I know you guys hate evictions, such a pain. Me too, me too. This is a way to get people off your property. The next one is kind of interesting, is the security deposit law. The answer is yes, a majority of times it is limited to 1 month. However, there is an exception that you can go up to 2 months rent, but you do need to read the statute, excuse me, because the rules are a little bit ambiguous. This starts on July 1st. So everybody is saying 1 month, but there is an exception for 2 months. But I recommend to my client, just take 1 month. Don't fall into an exception. But I'm just letting you know, because a lot of people are asking me, but I heard it's 1 month, but there are 2. This is the law. You can go to the law, read it to find out the exceptions. This takes a little bit longer. So evictions, since we're talking about evictions, there are 2 types of evictions, okay? There is the old way and the new way. That's the way I explain it. What is the old way? It's called just cause. And it's important because attorneys that do eviction talk like this, right? Every industry, there are only 2 things you have to care about: terminology, right? And procedure, right? So you're just learning terms, that's all. So just cause is just like before. Somebody doesn't pay rent, right? Somebody has a marijuana house, that's just like before. The new one is called no fault. Okay, so there's just cause and no fault. The no fault basically says that there are certain ways that you can evict somebody when the tenant is not at fault. So just cause means tenant is at fault. No fault means tenant is not at fault. The ones that I've put down here are the ones that we are typically using for no fault. No fault. One is owner occupied. Now here's the problem. The law changed. Before, all you have to say is, I'm coming back. That's all you have to say. Now, you need to occupy it within 90 days and stay for 3 years. Okay, so before it was, I'm just coming back, right? And the tenant would be like, well, how do I know? And the judge makes a decision, right? Judge usually says, well, if the owner's coming back, the owner's coming back. However, the new law says you have to move in within 90 days and stay for 3 years, right? Or tenant can sue you. The next one is substantial renovation. You're going to tear down the wall. You're going to like demolish everything, right? Before, all you have to do is just say it. Now, it requires you to prove it. So you need to give to the tenant all the documents, contractor documents, city permits, all of that you have to give to the tenant, right? So before, you just say it. Now, you have to show it. The next one is health and safety. Obviously, this is marijuana, grow house, stuff like that. And then government requirements, which are really health and safety issues. Okay. Next one is advertising laws. This one you probably already know, but just to let you know that SB 478, when you advertise and there are fees involved, you have to tell them what the fees are now. Okay, and that's under SB 478. And you probably have already heard about it for people that own businesses, but just to let you know. This is an interesting one, and it's called I call it the house flipper law. That's AB 968. And AB 968 says that if you own 1 to 4 properties and within 18 months, you purchase and sell a property, you must disclose everything to the buyer. Renovations, contractor documents, any permits, all of that you have to give over. So I call it the house flipper law, but I do recommend, because a lot of real estate agents do own property. Typically, I see them between 1 to 4. So they're doing real estate, but they're also doing real estate flipping, right? Because obviously you're specialized. I just want you to know that it doesn't matter if you sell it as is. The house flipper law requires you to give everything. So if you've done painting, construction, anything new, anything old, you have to give it over. Okay. This one, people have been asking me about ADUs. So the law is that ADUs can be sold separately. However, the cities have to agree as well. So it's a little bit different. And there are several clients that got in trouble because they sold their ADU, and I don't know how they sold it, right? I don't know who would take that case, right? But they didn't check with the city. And the city is like, what are you guys doing? Like, who are you? And they're like, oh, we just purchased the property. They're like, no, it doesn't work that way. So what AB 1033 and SB 976 does is it allows the cities to make a decision and the rules behind selling properties of ADU. So you need to go to Arcadia, go to Temple City. You need to ask them, what's your policy? Don't look at ADU and just think you can sell it. This one is very, very, very controversial. In my city, I have not seen a case like this yet. But when I read AB 821, so what's a general plan? A general plan is a general plan, vision of the future, okay? And then what ends up happening, I'll give you an example. Let's just pretend that across the street, it's just farmland. And the general plan says that in the next 8 years, because general plan is about every 8 years, all of this farmland across the street are going to become mixed use. But during the 8 years, they never change the zoning. They don't change the code. Technically, you have to have a zone change, right? But technically, the city can say no. Now, under this AB 821, the city cannot say no because the general plan said it. And a lot of cities are fighting against it. Why? Because cities say just because we have a general plan doesn't necessarily mean we're going to do it. Maybe we decided against it. Maybe across the street, we decided keep a farmland. But the problem is if the general plan says it under AB 821, it needs to be changed. This is very controversial. Developers are totally in love with this right now. Everybody's looking at it, investigating it, and figuring out what to do. Because what ended up happening with most cities is that the general plan is actually, it's very general. This one here is going to be mixed use. This one here is going to be single family. This one here is going to be et cetera, et cetera. But what ended up happening is that it was so complicated when people actually bought the property. And the rules were like so difficult that basically the state of California said, if it's in your general plan, you're done. You get it. And so a lot of cities are fighting back. But just letting you know, you should read up on the laws. Okay. Next, what we're talking about very quickly is negotiations. We've been doing this now. I think I started. We're in 45 minutes and now it's totally changed. So your mind has to cut off from lawsuits and laws to negotiations. So here are my tips. And I'm going to go much faster. When you negotiate, the right mindset is the key. I don't care about positions. I do not care about positions. I'm going to say that again. Everybody, when they negotiate, cares about positions. Do not. Let that go. Your mindset is the key. The goal of negotiations is to obtain information. It is not, I'm going to repeat it again. It is not to assert positions. Why is it when the FBI goes in, they're like, keep the guy on the phone. You know what I'm talking about, right? You watch the movie, keep the guy on the phone, find out what's going on. Why do you think the FBI cares so much? Why not just say, hey man, if you don't come out, we're just going to blast it. We're going to go in and you're going to die. Why doesn't the FBI say that? Isn't that the ultimate thing that may happen? They never do that. They never say that to people that take over an airplane, that ransack places. They always are getting information. Tell me about yourself. Tell me about yourself. What's your name? How many people are there? So why is that important? Tip number 1, increase the pool of knowledge. Get as much knowledge as you can. That is goal number 1 when you negotiate. The more information you have, the easier it is to negotiate, right? How many of you, right, have encouraged your buyers to write letters to the seller? When there's, you write a letter, oh yeah, I just want you to know that, right? Oh, I want you to know that I'm about to have a baby.
Add
And
photos.
yeah, this is a perfect house. How many of you guys are doing that now? A lot of you are doing that now. Why? Because once you figure out, you're trying to increase the knowledge, you're trying to increase the pool of knowledge, you're actually negotiating. right? If you did not want to increase the pool of knowledge, you say, hey, just want you to know, my price, not the highest, but you better take it. My client's super nice. Why don't you do that? You don't do that because you're trying to increase the pool of knowledge. You're negotiating by increasing the pool of knowledge. I don't know if that's a great example, but that's step number one. When you shrink the pool of knowledge, when you are shrinking the pool of knowledge, you're trying to get to a decision as quickly as you can. And that is the reason why negotiations fail. Tip number two, silence your mind. Silence your mind. I want you to know that your mind is super fast, and it's screaming. It's screaming. The problem is this, the other side's mind is screaming too. So what ends up happening is this. You think you make sense. The other side doesn't think you make sense at all. They think they make sense. You think they make no sense at all. I call it issues and noise, right? Meaning that if you don't understand an issue, you just think what the other person's saying is just noise. So going back to the prior slide, most people think negotiation is a battle of who is louder. The problem is that they think they can overwhelm the other side. I want you to know you're not going to overwhelm the other side. The reason why you have to silence your mind is because your goal is to get right information. If your mind is screaming, you cannot hear the other side. And if you can't hear the other side, you're ultimately going to just give your position. But your position is going to be noise. That's the problem. When you're able to get information, you're able to understand their issue. So therefore, when you talk to them, you're speaking to them about their issue, not your issue. And that's why you have to silence your mind. So I talk about issues and noises. Okay. Yeah, we're almost done. All right. The next one is telling yourself that the other side may be right. I'm going to say this again. Being on city council, I've realized that somebody could absolutely dislike me, absolutely be 100% against me. But if I say to myself, what about if they're right? Then we have a better conversation. I just silence my mind. So I'm going to give you an example. RV parking. We have RVs in our city. To me, they look like they're everywhere, but they're not really everywhere, right? So there's an RV, it's right up there, blocks out the sun. It's gone, huge, right? But yet, here's the problem. Shouldn't a person that buys property be able to park what they want on their property? I guess so, if you buy a property. At the same time, doesn't the way the community feels, is that important? Well, that's important too. Why can't they be both important? So when you negotiate, why can't you go up to the other person and think, they're right, and talk from their issue? I'll give you a further example. On one channel, you have the overtime of Super Bowl and the last episode of Seinfeld. Here's the question. Which one on this channel should you play? You can't play both. That's the way life is. You should always be thinking the other side is absolutely right. Because if you can talk that way, you can negotiate better. All right, nobody watches Super Bowl or Seinfeld. Maybe Mike does, but apart from that, I watched Seinfeld. I loved it. The next one is slow it down. Now, this seems like a very easy tip. Slow it down. But the reality is you need to start practicing how to silence your mind by just slowing it down. Now, I'm going to show you a way to do it. It's very easy, right? Very easy. Just repeat 2 to 3 words of what the other person says. All you got to do. How many of you have met elected officials, right? Right? And you go up to them and you ask the question, why are you running for office? Right? And they give you 10 minutes and you're like, after 90 seconds, you're like, oh my God, I asked the wrong question. How many of you have been that way?
Many times.
All the time, right? What did you just want them to say? Why are you running for office? Because I love this country, right? I just want to serve. That's really, right? Isn't that it?
Yes.
I share this with you because an elected official, they're so nervous. I'm nervous too. And when you are asking them, really what you're asking them to do is just repeat 2 to 3 words of what you're saying, right? So like, if, I'll give you an example. Someone comes up to me and says, I'm like, hi, hello. Okay, you be an Arcadia resident, right? I'm like, hi, hello, hi, how are you?
Good.
Good. Well, great. Thank you so much for allowing me to come to give you the respect that you deserve. How long have you lived in Arcadia for?
Um,
10 years?
5 years.
5 years? That's great. Do you love Arcadia?
Yeah.
I do too. And that's the reason why I'm running. I love it just like you do. Do you see what I did? Is I only took 5 years and I made it into a conversation about her. I have nothing in my head at all. I'm just trying to increase the pool of knowledge, get the information, right? Why'd you move to Arcadia? Right? Oh, I moved to Arcadia because I'm about to have a kid, right? And this is a great, that's the reason why I moved here too. If you silence your mind and you repeat the 2 to 3 words of the other person, you increase knowledge and it just gets bigger and bigger and bigger so that you can use that information to negotiate. The next one I would say is embrace the accusation. Before you meet with the other side, write down everything the other side is going to say about you, every bad thing, and deal with it. Why would you want to do that? You want to do that because, again, tip number 1, right? Increase the pool of knowledge. Tip number 2, silence your mind. If you don't do this before you meet with the person, the only thing that you're going to be doing when the other person's talking to you is defending yourself in your head. And then the noise in your head is going to get too loud that you cannot hear the other side. So this is what I call as an accusation audit. The next tip I have is called creating attentive safety. And I try to do this on city council as much as possible, because if you see, every person is really just a child in their heart. Excuse me. And really what you need is to create a zone of safety so the other person is comfortable about talking to you. I call it the ABC. I approach by acknowledging, agreeing, admitting, and apologizing. That's A. B, I build the bridge together. And C, I compromise where I can. Compromise doesn't necessarily mean you win. That's when I give the solution. That's the compromise. So for example, let's say someone dislikes me, whether it's on opposing council, whether it's on city council, or whatever. The first thing I'm going to do is I pull out this PowerPoint and I look at it. So what am I going to do? I'm going to approach. I'm going to say, you know what? Thank you so much for loving the city of Arcadia. I totally agree with you that we have to move this forward. This issue is so important. I apologize. I apologize if you feel that I'm being cold. That's just my personality. You know, that's not my goal. And then you bridge together. Hey, can we, let's talk about this issue together. And then you compromise. You talk about a solution, a win-win solution. So most people want to get to their decision right away, but you need to do the ABC. The ABC again is you approach the person by acknowledging them. Thank you so much for sharing your thoughts. Agreeing with them. I agree with you. How many times have you been in a nasty conversation and the person says, I agree with you? Boom, everything stops. Wait, what do you mean you agree with me? The first thing you're going to do, acknowledge them and agree with them. And then what you're going to do is you're going to admit to them what you can agree on. Not saying that they win, not saying that they're right, but there could be something that you can agree with. There's always something you can do. And I recommend apologizing. All of those things put together, makes the bridge that much easier to walk on. And then you present the compromise. Right? So I'll give you an example in the real estate context. You go up to an agent and you say, hey, thank you so much for taking my call. I completely agree with you that you have to be passionate for your client. I am too. I am too. And I want to just tell you, I'm so proud of you for just working so hard for your client. I'm sorry. Maybe I've been a little bit aggressive because my client really does want the property too. Yeah, and I know you have so many other people that you can select from. But I'm just really hoping that you can really consider my client because of the fact that they're having a child and this is their dream home. Does that make sense? It's a little bit different than just calling up somebody and saying, why'd you yell at me? You're just a jerk. Circle is really small. I'm gonna take you out. I may be weak now, but one day I'm listing and you're gonna be the buyer. You understand what I mean? Big difference. Okay.
Happens often.
It happens a lot. Okay, we're almost there. How many of you have gone to a store and the agent comes up to you, right? And you're like, hello, sir. Hi, how can I help you? And you're like, no, I'm just looking. And they talk, you say, no. How many of you have done that?
I have,
We've all done that.
yeah.
How do you feel after you do that? Usually,
Guilty,
but powerful.
relieved.
You actually feel powerful, am I right?
Yeah.
Right? Because nobody wants to say no. I want to tell you in negotiations, encourage the other side to say no. Welcome it. It's okay to get a no. Because negotiations is all about making the other side, silencing your mind, the other side feeling safe and in control. Safe and in control. And the way to do that sometimes is to get them to say no. Because once they say no, they feel good. And when they feel good, that helps you negotiate, right? So never feel bad when someone says no. You need to let them feel safe and in control. No allows the other person to feel safe and in control. No allows you to get more information, right? Many times I've negotiated and the other person says, can't happen. And I'll just ask, well, thank you so much. How can we make it happen? And they'll say, you know what, if you gave me another $10,000, maybe we can make it a deal. Information just opening up, right? I'm silencing my mind. I just want to give them control. I just want to listen to them. That's all I want to do. And the information just comes flying in, okay? Focus on the and question. I actually created this when I was on city council. Is one of the reasons why people feel on city council I'm nice and I don't yell at people on city council is because of the fact that I always have two questions that are in my mind. One, what do I really want? Two, what do I really not want? Three, I combine them together. Four, I act. Does that make sense? No, it didn't make sense. Okay. Most people focus on what they want, right? Or they focus on what they don't want. What you need to do as a negotiator is you need to say, what do I really want? What do I really don't want? And if I put them together, would I act this way? So why do I not yell at people on city council, even when they disagree? Apart from the other tips, silencing my mind, etc., one of the things I want is I want them to think the way I think. What do I not want? I don't want them to vote no on everything else in the world. So when I talk to them, of course, I'm going to be professional to them. Of course. And that's the way you should be too when you talk to people. It shouldn't be about positions. What you want, what you don't want, you add it together and you act. And 99% of the time you will act really professional. Be careful when it is unsafe. Unsafe means there's a change in the room. So somebody came up to me, right? She messaged me later. She said she never said it. Fine. She came up to me and she was like, "Oh, I've known you since you were a little kid." I was like, "Oh, thank you so much," because I've been around like almost 50, right? And she's like, "Yeah, oh, how old are you?" I was like, "Oh, I was born 1976. Oh my God, you're like older than my son." I'm like, "Oh, okay, thank you." I was not thinking anything. And then she said, "Hey, 你发福了." Right? That's an Asian way to say you get fat, boy, right? Because 发福 basically means that you're living a great life, man. It's like great life. It's like you can tuck money between the folds of your sides, right?
Wow.
Right?
That's like an indirect compliment.
No. So automatically, what did I do? I froze. It was right before a lecture, just like this. And I was like,
I'm fat.
right? I was like, thank you. Right? I didn't even know what to say. Now, why do I share this with you? I share this with you because she kept on talking and she was not aware that it became unsafe. Now, the word unsafe is used loosely, but I want to share with you two things because typically we're like having a good time, we're just talking, right? And all that. And unsafe occurs when there are two things that occur. One is silence, but silence is a little bit different. The second one is violence. Silence can occur when a person becomes silent or they begin to become sarcastic or they begin to avoid or withdraw from the conversation like I did. You need to be self-aware to know that there's a problem that just occurred. You need to get back to my tips as quick as you can. Because when it's safe, you guys laugh all the time, right? Oh my God, I hear, oh boy, we talk about Asian people. Oh yeah, oh, and Asian people are just always laughing at each other, right? If somebody says something like, "Hey, are you racist?" Right?
Uh-oh.
That signals to you, that sarcasm signals to you it's unsafe. And you have to be careful about the next words that come out of your mouth if you're looking to negotiate or keep a friend. The second one is violence, where a person just begins attacking you. Boom, they just begin attacking. Or they try to control the conversation. Those are two signals to you that the room is not safe. And you need to silence your mind, repeat 2 to 3 words of the other person, and just slow it down. It's no longer about your opinion anymore, right? The next one is that I find that most people fall into 3 types. They are either ants, bulls, or butterflies.
Be careful
Yeah.
before you identify.
All right. There are 3 main types of people that I notice in negotiations is ants. Ants are very data-driven people. Ants are actually quite arrogant. They do not trust anybody else but themselves. Why? Because they're data-driven, right? They are usually distant. They are usually quiet. A lot of people think they're introverted. Some people may think that they're judgmental when they talk, but they don't talk very much. The next one is a bull. A bull is a bull, right? They're usually very expressive, loud, opinionated, strong, right? The next one are butterflies. They are very connected to people and relationships. They get on the phone and you're like, oh my God, that person's calling again. Here's another 20 minutes. They want to ask you about, how's your mom? How's your sister? How's your brother? You're like, oh my, I told you 5 times I don't have a brother. Oh, okay, all right, oh, sorry. It's like, right? Those are relationship-driven people. Now I'm going to show you how to deal with these 3 types of people in negotiations. So I explained an ant is usually methodical, diligent, calculated in a good way. Every step they make is a step that has meaning. All right. They are decisive. Ants are very decisive. A good example, although I don't know if they're all ants, but doctors are kind of like ants. They're very decisive, data-driven, right? They know you're going to die 3 months from now. You're just going to die, right? They don't sugarcoat anything, right? And they just trust themselves. that's kind of just an example. We have to keep on moving forward. So, what is a bull? A bull is about getting a job done. Bulls are actually most generals, most people in military, conquerors of the world are bulls. They cut off other people, right? You talk, they have an opinion. You talk, boom, they don't want to hear, they just want to hear themselves talk, right? It's all about getting things done, right? They do not get easily offended, but they don't understand why everybody else is offended, right? Right? I don't understand. I'm just me. They always say that. I'm just being me, right? Accept me, right? And they have loud voices and they're strong. They are passionate in their speech. They double down on statements that are untrue. It's untrue, they double down, right? They just double down. Why? Because they're trying to get to the end goal. You know what I mean? Whenever I smile, I'm always thinking, I obviously did not silence my mind. I'm thinking about all these bad examples in my head. Okay, next. They will say harsh words to make their point known. They mean like stare at you, right? Harshly, right? Okay. What is a butterfly? A butterfly are connected to relationships and people. Time's not money. Time is relationships, right? They praise other people, right? Oh my God, right? Nancy's hair is great, but it would be like, Nancy, your hair is so nice. She always has nice hair, right? But that's first thing a butterfly is going to do. They're going to talk about other people. The problem with butterflies is that they are easily depressed, discouraged, or hurt by other people, okay? They're worried about hurting other people all the time. Many elected officials are butterflies, right? And the problem with the butterfly is you really don't know how they really feel because they're scared to hurt other people. So how do you communicate with an ant? You communicate with an ant by being overly prepared when you speak with them because they respect others that are prepared. As soon as they feel that you're not prepared, done, conversation over. They may look at you, but they're not looking at you, okay? You need to speak slowly and carefully. Do not be afraid if they do not respond to you. Because ants feel silence is when they're thinking, and they're okay with silence. Ants trust themselves. I talked about it earlier. Do not make a promise to an ant because they're so data-driven. Ants will remember a broken promise years later and will not trust you at all. Right? So you don't understand. Why doesn't this person trust me? I've worked so hard. I've done 5 deals with them. Why? Because you lied to them 5 years earlier. Because everything for them is data. That's all they care about is data. Bulls. How do you work with the bull? The bull wants to be heard before they hear other people. They make statements they don't mean. Example, I'm disappointed. I'm insulted. Let them express themselves. There's nothing wrong to allow a bull to express themselves. And what I typically have realized with the bull is you're not going to change their mind. They are the ones that change their mind. They will never say, oh, thank you so much for saying that. I totally didn't think about it. No, but you have to talk to them, slow down, inquire, allow them to explain their position. Because you have to remember, a bull is all about getting things done. They make statements that are untrue. They don't believe it. The more you allow them to talk, the more self-correction they make. They make the correction on their own. So the bull goes whoosh, and then it goes whoosh, and then it goes whoosh, whoosh, right? As long as you allow them to do that, they will correct on their own. Because the more you talk as a bull, the more you realize that your positions really aren't that good. But you can't tell the bull, you don't make any sense. You got to allow the bull to make that decision for themselves. The next one is, the bull are not bad people, right? Communicating with butterflies. If you work with the butterfly, this is very worrisome. You need to start by being positive and affirming to them. If they say yes, you need to ask them, 3 to 5 times in different ways, whether they mean it. How many times have you invited an elected official and they just never came? And you're like, I don't get it. What happened? Right? The elected official probably had a conflict. They just didn't tell you. They were afraid to tell you. So what would they rather do? Just not come. Empty chair. I've had that situation happen. I've invited elected officials and it's an empty chair. You're so upset. So you got to go up to that person when they say yes, particularly when they say yes, and ask them in 3 to 5 different ways. Do you mean yes? And you got to be excited for them when they say no. And you have to encourage them to say no. Because ultimately you're trying to get a deal done too. And if they sit there and they're so worried about a broken relationship, you're never going to know what they're thinking. So this is very important with the butterfly. Be kind, be affirming, encourage them to say no. These are all big things that help. All right. Very quickly, in terms of working with other people, the first thing you have to recognize is, who are you? Are you usually a bull? Are you an ant? Are you a butterfly? You need to figure out who you are. Many times it's very easy. You just have to ask yourself how you reacted when you were a child. How did you survive? At the end of the day, we're all just trying to survive. You know what I mean? How many times have you woken up, you're like, I can't do this anymore. I think that way. So do you. Recognize who you are. The second thing you need to do is recognize that the other side has 2 out of 3 chances. They are not you. They are not you. I may be a butterfly. I cannot expect every human being to be a butterfly. I may be a bull. The other side may be an ant. Once you begin recognizing that, you'll feel more comfortable when they act a certain way. And then you need to communicate with them from their standpoint. From their standpoint, not your standpoint, because you silenced your mind. Four more slides and we're done. I just want you to know that this is what I call the path of the mind. And I share this with you because most of us, when we see this thing called expression when we get offended. So most people, they hear something, see something, or they're told something. And if the reaction in their heart is what I call FUD, fear, uncertainty, or doubt, they will immediately have a story. Immediately have a story in their head. They don't ask you, they just have a story. Then they justify that story and then they express it. So why do I share this with you? Your goal is to gain information. So you don't look at someone's expression as the truth. You begin to go backwards. You begin to realize they've said that because they believe it. Right? Instead of saying, how could they say that? They're so stupid. They should know the truth. You should say to yourself, he yelled. He felt justified in yelling. And then you begin to go backwards through the path of the mind. And if you're willing to do that, you will slow down when someone upsets you. You will realize that they've had to go through all of this. How many of you you're like, oh my God, I was on WeChat and like, can you believe Sarah's out with that guy again? Right? Right? I know. Bobby wasn't that nice to her. I bet you Sarah's like, doing stuff on the side, right? It's okay. We're in a safe place. Uh-oh, it's silent. Okay, so anyway, in terms of, that was funny in my head. Zoom people think I'm an idiot, but what I'm trying to give you an example, I'm giving you an example by letting you see how that story, because I said that story, everyone was like, oh yeah, Sarah. Oh, it was actually Jessica, it wasn't Sarah, right? You already went through all of this already so quickly in your head. And then it's the expression. So the expression, when people express poorly to me, that is the reason why I'm so calm, because they went through this without actually knowing exactly what happened. Okay, we're almost done. Here are some other tips. We love dogs because they wag their tails. Always be genuinely interested in others. How many of you have dogs? Have you ever looked at your dog and they're looking at you and you're looking at them and they're looking at you and you're trying to communicate with your eyes and you want to cry.
All the time.
No, seriously, you actually, he's like, I'm too masculine to cry. No, you actually feel emotional. So if an animal that cannot speak English would make you want to cry, you must understand that you must be genuinely interested in others. The only reason why you want to cry is because you think your dog wants to talk to you. And it's so sweet. So if you know that that is true, then you should be genuinely interested in others. And you don't have to talk to do that, right? You don't have to talk to do that. The second one is a person's name. I have to admit, I'm very bad at names. I'm good at faces, really bad at names. And I have to say this, names are so important. Not when you degrade somebody, Paul, no. But you have to understand, if someone's name wasn't important, why do they give millions of dollars to name buildings after them? Don't forget someone's name. When you look at a photo and you are in that photo, do you look at anybody else first? You look at yourself first. Am I right? Right? If you look at yourself first in the photo, that tells you one thing. People care about themselves. So when you talk to somebody else, you have to realize, stop caring about yourself. Silence your mind, repeat 2 to 3 words, and listen to them. Because that's what negotiation is about. Distrust your first reaction. Like earlier, I talked about the path of the mind. Distrust your first reaction. Your first reaction is always bad. Your first reaction is this. When someone does something to you, your first reaction is, you're a liar. Boom, fear, uncertainty, doubt comes in you, right? And then you immediately have a story. And then you immediately justify it. They're wrong, they're evil. And then you express. Always distrust your first reaction. That is so bad. Praise somebody before you criticize them. Everybody has something good about them. Always say something positive about the other person before you're critical. I always recommend, but a lot of people don't like to do it, I don't like to do it either, is to talk about your own errors. Because if you're basically saying that the other person's going to make an error, if you've made the same error, why don't you share your life story? If you are going to open up, you might as well be honest about it, right? If you are a winner, never, ever acknowledge it to anybody. I remember there was this one attorney, he totally crushed me in a settlement. I don't know why, the client just caved in. So upset. And I remember him walking out, he was an older attorney, so smart. He said, I hope I never litigate against you again. You're just so good. And then he just walked away. That is so brilliant, right? Where most people, they will call up, have a drink of wine, they're like, hey, I just want you to know, Paul Chang just settled the worst case in it. Can you believe it? No. If you're a winner, never say it to anyone. Always praise the other person. Always praise the other person. So this here is outside of our state capital. This. Nobody ever knows about it. You know why I know? Because I actually went up to an elected official. I can't say who because a lot of people know him. Wasn't Newsom, right? He wouldn't even talk to me even if I said hi. I tried to. And I said, hey, do you know about the statue? It's literally right outside the Capitol. And they said, no. These are the nuns. They're called the Sisters of Mercy. They came in 1857. They sold the state capitol to California. So the California state capitol is because of the nuns. They provided California's first health, education, and welfare. Okay, why do I share this with you? This is a nun. This is a mother with her dying child. This is another nun. Do you see this here? This right here is a Chinese orphan. In 1857, there were many orphans that were Chinese. Many people came over and they just left their children behind. And non-Asian people loved them. Now, why do I share that with you? I share that with you because in 2024, race is so big. But I want to remind you that from the beginning of California, each race loved each other. The story that's in your head about the person that was mean, 1% of your life, less than 1%. The 99% of people, how amazing is it? We are going to go into elections in 2024 November, and both parties are going to tell you, if you don't vote for their party, you are the biggest idiot in the world. And the whole world is going to collapse because of your one vote. I want to share with you this. During COVID, did President Trump knock on your door? No. President Biden has never knocked on my door. My neighbor knocked on my door. You knocked on the neighbor's door. And I share that with you because at the end of the day, it's not about who's president, it's about you. And it's about being a neighbor. And it's about being good. Because the best days of America are coming. They're coming because of us and you. And your dedication of acting the same way as you did during COVID, which is respectful, which is sincere, which is hopeful and innocent. All of those things are the reason why we made it through COVID. So I wanted to thank each and every one of you today for allowing me to come. I don't know if you have any questions. I know I took a lot longer than was necessary. We do have a question from Mike and a second question. So yes, sir.
Going back to the lease situation.
Yeah.
If a homeowner needs to move back to their home
Yep. Okay.
and they have to be in it for 3 years.
Yeah.
What if circumstances change and they want to sell their home?
Yeah. So I've gotten this question a lot. I see what the law says. I did not see any exceptions to that. Obviously, death is an exception. But I have not seen any exceptions to that. So if you're going to come back, you're moving in. Now, a lot of people say, well, how do we prove, right? I mean, is the tenant going to come back 2 years from now and make sure that you live there? Probably not. But there are a lot of attorneys that will. Right.
So if they had a job transfer, they have to leave, they're stuck.
They're
Is that
stuck.
correct?
They're stuck.
That's very interesting.
Yeah.
Are things like this just not thought out properly, or the intention?
You know, we actually had the same issue that we had in Arcadia, a little bit different. It's about artificial turf. There were residents that came and said, hey, look, we have drought. Residents that came and said artificial turf is poisonous, bad for the environment. And what I always say is that elected officials, whether we agree with them or not, and I don't agree with this law, obviously, when I talk about it, you can tell, is laws always have good intentions, but unfortunately bad consequences. And the higher you go in government, they don't have to deal with the consequences. Local people like us, we got to deal with this. Wait, I'm stuck. But unfortunately, a person in Sacramento, yes, they live down here, but they're dealing with policy and theory. So the higher you go, it's all about policy and theory. How many of you guys, like, you have some rule coming down from the Association of Realtors, and you're like, that's stupid, right? The consequences are ridiculous. But the reality is that when you are in large entities, you deal with policy and theory. You don't deal with consequence. So that is my response to you, is that, yes, I think it's going to be, yes, I think it's stupid, right? People should not be stuck. The free exchange, there's actually going to be lawsuits over this, I believe, but the free exchange of buying and selling property, I believe is a constitutional right? Life, liberty, or property. And so I believe that there's going to be litigation over this because of the fact that I think it's unconstitutional. It's just unconstitutional. I should be able to buy and sell my property when I please. But, HOAs have a bunch of rules too. Some of them I think are very inappropriate, but they've been upheld. Next question. Yes.
I have a question just for this eviction.
Yep.
How about this one for rent, but how about if the landlord want to sell the house, it's okay, but no.
Yeah, so this is, okay, when I was preparing for this slide, so I've got to be very frank. This law, when you read it, has very little exceptions. And I'm putting this together as quickly as I can. Because somebody else asked me, it's actually a very similar question. You're basically asking the same question, which is, what's going on with the exceptions? Are there any exceptions? Why are we locked in? And the answer is that I can go back, I could read it again, but I don't see any exceptions that allow for unlocking of your property. You're basically, you've got to move in, you've got to stay. Why? Because it's no fault. If it's just cause, you don't have any of these requirements. Okay, so again, maybe I was not clear. Just cause, they're gone forever. It's the fault of the tenant. No fault is not a fault of the tenant. It's a landlord decision to do something. And because it's a landlord decision to do something, because the tenant did not do anything wrong, and because they're saying that there's not enough property to lease or purchase in California, these type of rules occur. Okay? Yes.
This question we have in my life. When agents are putting together a listing contract with the seller.
Mhm.
And they're discussing the commission to be paid. And under the new guidelines, from the lawsuit. Can the listing agent say to the seller? Are you open to paying a buyer's agent commission, and if so, how much?
Well,
Is that legal, or has that been taken away? And then can that total commission still go into the listing contract where it's broken out? For example, the seller says, yes, I'll pay you 3%. And I'll contribute 1.5% to the buyer's agent. And they can negotiate with a buyer broker agreement, the rest of the commission with the buyer. And they put the two together.
okay.
Is this legal?
okay,
to have
one-
This discussion.
One, I kind of got lost in your facts, I have to be very frank. Two is that I've not taken the time to read about all the commission changes that have occurred, but
Fair.
this is what I do want to say. Is that there is, disregarding what's happened recently, there is no law that says that a agent representing a buyer needs to get a commission unless you have it in writing. So why do I share that with you? I share that with you because there have been disputes where the listing hasn't paid and it's gone to court and the courts have said that there's no agreement. Now, I understand that you guys have arbitration, and the arbitration among like West San Gabriel, et cetera, have basically said if you breach an ethical obligation, that you will still get paid. So not dismissing what Mike had just said, but I just want to share with you is that if you are going to want a commission on the buyer side, you have to get it in writing. Oral statements are not going to work in court, but in arbitration, so far that I've seen, it seems like when there's an ethical breach, because basically if you don't get paid or, you know, the listing goes around you, and you were representing the buyer or the buyer found somebody else, most of the associations that I have seen have basically ruled in favor of the buyer's agent in arbitration, but not in court. So my recommendation on a commission dispute, when it is what I consider to be ambiguous, but for you, it's an ethical, like, I can't believe that happened, go to arbitration. They will support you more often than not. But if you go to an attorney, he's going to say the same thing. What law do you have that allows you to get the commission? Oh, it's an ethical, you know, it's online. Attorney's going to say, I can't help you. I have been seeing a lot of lawsuits that was not on here, that basically where somebody is, you are listing and somebody basically has brought a, you've been able to procure a buyer. And basically the seller won't give you a commission or basically sells around you or goes to another listing. I just want you to know the law is very clear that you are required to get commission, even if there's no purchase and sale through you. Because of the fact that you've brought somebody that is ready, willing, and able to purchase. The question becomes in those cases, how close is close? I can tell you that if you put it out there on the market for 1.2 and someone comes at 1.2 and the seller says no, you're entitled to that commission. Just let you know. Did I make any sense? Or people,
Absolutely.
yeah, that it's pretty shocking because I understand that you don't want to have a bad relationship with the seller. And so you just kind of like let it go. But I just want you to know you are entitled to that commission, even when there's no sale. Even when there's no sale, like some people are like, well, shouldn't there be a sale? No, you actually brought a ready, willing, and able buyer. That is in the contract. That's the requirement. And basically the law is very clear. As long as you bring somebody ready, willing, and able based upon the sale price of the home or commercial property, you as a listing agent are entitled to your commission, even when there's no sale. We veered totally away from what Mike was saying, and it was not to dismiss. I always feel bad because like people get up to lecture all the time, and the scariest thing is to have questions. And they always seem to veer away, and I feel like I did that, but I just have to be very honest. I'm not on top of the commissions right now. I've just been really
And I'd
busy.
like to bail you out a little bit,
Yeah,
if I may, with
Yeah,
that.
yeah.
So this morning, there was almost a 2-hour session with CAR over at West San Gabriel. And even the attorneys, the general counsel from CAR do not have any answers, clear and concise answers as of yet. However, it is expected that by mid of July, the purchase agreement is going to change. The broker compensation agreement is going to change. There's going to be more options to choose from. At the end of the day, the commission is, now they're using the word compensation because it's something that I've been at the forefront of to change it from commission to compensation. It's negotiable. No matter what, it's negotiable. But you do have to secure it, procure it in writing. And Kelvin's been talking about that from the very beginning. We've been talking about that for like the past 1.5 years, 2 years. So now we're in the vortex of the funnel of this hurricane where we need to start practicing. This is why Kelvin and I invite you to start having hands-on practices to where we can start having the interview, because a lot of 3 listing appointments I've had, I took 2 out of the 3 and walked away from 1 because a conversation from the seller was I refused to pay the buyer's commission. But when you get into the conversation of negotiating and you get deep into it after the interviewed 8 realtors, sometimes you have to pick your battle and say, you know what, I think we're going to walk away from this one. But doesn't mean you're not prepared. You need to be prepared because it's happening. There's agents already out there, realtors already out there that are doing fee schedules. And the fee schedule is about how much am I going to charge my buyer if I show them a property? How much am I going to, charge the buyer on the mileage? So it's really opening up to something bigger. So CAR is predicting that after all these lawsuits, and I have the statistics and I'll share them with you once I type them up. I was trying to type them up, but Paul's presentation, even though it's the second time I've heard it, is so interesting. It is the buyer's class action. So they're anticipating that the buyer's class actions are coming post 2019. What does that mean? I don't know. And the answer you're going to get from general counsel is they don't know. So it's opening up to something bigger. So the lenders, what's going to happen when the lenders, when some lenders get paid on the back end from the banks, an extra amount, is that open to everybody else? There's just a bunch of stuff that is just, it's scary, but I say change that fear into energy and continue to work, because the good people that are out there working, every single one of you are going to continue to go forward.
Mike, I'm gonna check the 1482. I'm gonna read it. I'm gonna email back
Sure.
to check that 3-year. I'm looking at the final code. I was typing a year. I was typing in 3. I didn't put in the number 3. I just typed it out. So I didn't see it. I'm gonna check that. I'm gonna check that. Because that's pretty important. We don't want inaccurate. To be able to see if we can find the exceptions for it.
Right.
Thank you for that, Paul. Any other questions?
Yeah.
I
Martin?
just wanted to add that, right, if you go into any, what do you call it, an internet engine, whether it's, you know, Safari, whatever, you just type in facts.realtor,
Right.
it'll take you straight to a website from the NAR website, and it has a lot of information about this.
It does.
I've
And there's a
reviewed,
section on there that's called Q and A.
Very
If
helpful,
you
yeah.
click on that, a lot of those questions are kind of, they're trying to answer those. I don't know if you
So,
want to.
so the FAQs,
They
the
don't
new
know.
FAQs are gonna be out by mid-July. So the new FAQs are gonna come precisely about all of this mid-July. So,
That's one of the questions.
yeah, frequently asked questions,
yeah,
frequently asked questions, under risk management, which is what Kelvin has.
Facts.
Frequently asked questions. I don't wanna hold Mr. Cheng here more than he needs to be here, but if he wants to stay over and go over some information with you, it's totally up to him, but I want to formally, on behalf of Kelvin and I, say thank you, Paul.
Thank you.
Appreciate you. Thank you.
Personally speaking, I love the energy and passion Paul just shared with us. Many of his tips for negotiation are actually true and found proven methods and strategies to get what you want. Again, a lot of that does mean having to acknowledge the other parties' concessions and ideas, and I love that pool of knowledge, and I'm always a person that like an ant. I'm soaking up knowledge every day. And I'm always letting the other party speak first. And I'm always trying to understand what their position is and what is their want. So I can be a better problem solver for you, sometimes for you guys, correct? So his methods, I totally resonate well with all of that. Thank you again, Paul, for sharing. I honestly didn't realize it was gonna be a three-part learning discussion, because not only is it about negotiation, he talked to us about the new laws, and then he talked to us about teaching us how to be a better agent to help the attorneys. And so I thought that was that compounded to a lot of education in just a single hour. What I want to share with a lot of you guys is the answers / my opinions and perspective of the Department of Justice is a potential agreement to settle with the NAR, because NAR has made the decision to make a settlement, pay financial fees, substantial, I think it's $680 million in fees, and also make concessions on the way we do our business practices and commissions advertised in the MLS. So I will be sharing an email that's already halfway written. I got to finish it up, and then I'll be sending it to you with Martin's link, facts.realtor. I have other links. I have another invitation to join a session on Friday if you wanted to listen to someone else's opinion. I'll also give some YouTubers who really describe what's going on and the repercussions of it. But yes, the settlement appears to be going into be inked as far as the industry and the shockwaves. Many people are talking about it. So you will find multiple discrepant information. You can see headlines saying, oh, the realtor industry is doomed. There are gonna be headlines saying buyer's agents are gone. Okay, this is gonna be dramatically a lot of different hypothetical assumptions that will happen. And I agree with some of the assumptions. Yes, I do agree. This is a negative thing for realtors, for brokers, and for the industry. I think it's negative for sellers and buyers. I do think so. That's my opinion, though, because we don't know what the outcome is going to be. And just like he said, we don't know when there's law written, there's a difference between the actual practice of that law and the interpretation of that law. And we don't know, there's always going to be some revisions or exact timelines or procedures when everything has to be all changed. But what we do need to change is the style and way you educate your client and inform them about how commissions and the transaction works. We need to be sharper in how we defend our value, how we justify the services that we offer. And in many different instances, it will make probably us having to sign a formal agreement with our buyers. which many of us, 99% of us haven't done that yet since today. Okay? How many of you have ever had to sign a buyer broker agreement? Just 2, 3 of us in a large room, okay? And so then if you have done it before, kudos to you. You've actually put together what you needed to hopefully earn for your potential work while representing a buyer. And that buyer was willing to sign it and agree to your terms mutually. It still is negotiated. They can negotiate the rate. And obviously we still make our full attempts to obtain it from a seller through a request. The industry is not gonna technically change too much for us in California, because we've already experienced in San Gabriel Valley, multiple brokers who only advertise at $1, $100 on their listings. So that's essentially just like a zero. So many of us who've had to deal with their listings, we already know what to do. We're gonna still try to show their property, and we're still going to write an offer with a condition, and we're gonna attach our Form CBC, Cooperating Broker Compensation, to modify that our offer is contingent upon us getting X amount of commission that we would like, okay? And if you didn't, in theory and practice, that's gonna be what our transactions are gonna look like mid-July and forward. But instead of a CBC, they might change that form to maybe what you have was called the ABCD form, or the anticipated buyer's commission disclosure form, where that's kind of like the buyer broker form. Okay, so whatever form we're going to be using, it's not going to be too hard to fill out. It's going to be something that you and your buyer agree that maybe in exchange for my services of driving X unlimited hours and gas miles and time spent and offers written, irregardless of I got to show you 50 homes, 100 homes, or 3 homes, I should be earning a commission of what we mutually discussed and negotiated of 2.5% or 3% or whatever your rate will be. That buyer will get a promise of what kind of limited or full services that you provide. So you probably have to describe what some services, just as rapid writing offers, providing a buyer's CMA of the neighborhood. Maybe it's going to be offering to give a rental analysis of the property. Maybe your good services would be to drive them around to as many homes, and you're the driver. Okay, whatever the services you're providing or limited services you're providing. My first comment on what the West End Gabriel, whether I should charge per hour or per showing, any commissions or monies collected from you, you are not to be paid directly from the consumer. Okay, that's the that's our licensing body. Department of Real Estate does not allow an agent to receive compensation at this moment directly from the consumer. You must be paid by your broker. So if you're going to charge an hourly rate for your work, you could, but you have to have a discussion with your broker on your contract and agreement that you're going to be putting together. Okay, because you are all independent contractors, yes. Okay. I don't even have an agreement to share, because this is all brand new to us. Michael, you have a question?
Yes, I'm sorry to be so talkative with my question.
Okay.
But things just pop up. Could we be headed for some procuring cause issues?
Yeah.
Because the media has been discussing and informing people that, well, buyers can now just go look at homes on their own, which would mean they'd be calling the number out front, asking the listing agent to show the house, and referring to non-open house days, where the listing agent shows the house. Then the buyer goes and negotiates so they can have their own representation, because they don't want to have the seller representing them. The agent writes the offer, and now the listing agent says, well, I'm procuring cause for that because this person came and it was not an open house. So they're not going to. You see where this could be?
Absolutely.
A big issue, because buyers are going to begin to think, well, we can do all this work And then we just pay the buyer's agent at a discount just for writing the offer. It's almost like the fiduciary duty is gone. The buyers just think they're gonna be doing paperwork. And,
And liability is
and
still
the
there,
liability
okay?
is the same as the listing agent's liability, but maybe the buyer's broker is getting a lot less. So I'm envisioning things that have not been thought out when this law was put together. And it could cause quite a bit of trouble.
Okay, and to the YouTubers out there in the video on Zoom, just to repeat, there are definitely a lot of repercussions that have not been thought out of. And he did make a good point and comment regarding there could be issues on procuring cause. There is going to be situations where buyers can be of 3 different categories when they see a property on the MLS. When a buyer is trying to find a property, they're going to find themselves either A, they're going to be unrepresented. B, they're going to come in represented with their own buyer's agent that they signed an agreement with. Or C, they're going to come in and ask the listing agent to do the services they need, which is to help them write the offer on their behalf. Okay? That's the only 3 they can have. Represented, asking the listing agent to do it for them, and negotiating that fee. 3, coming unrepresented, and the buyer is going to agree to the contract at their own risk without any representation. And so in the industry wide, there's pros and cons of every single one of them. Okay. What we as practitioners know, because we do this in a daily basis, we know there is a great risk of a buyer entering into a formal contract binding without representation, because they're not knowledgeable about the nuances of a transaction, about the exact disclosure duties of a seller or an agent have, and they're not going to know the timelines, procedures, and the repercussions of every single term on that paragraph that you and I both know well, so well. So there's a great risk to the buyers coming unrepresented unless they're sophisticated or experienced investors. Sure, maybe some sophisticated investors or buyers like myself, I can go into an agreement without any broker or any agent, and I'll feel quite comfortable because I know my laws. Okay. Then there's the buyers that come represented with their own agent. Great. They got their own agent. They've written into their own compensation agreement that they are willing to pay for that representation of a buyer's agent, and that buyer's professional will be protecting them and giving them agency fiduciary duties and writing offers on their behalf, just like normal. And then there's going to be the ones where the buyers will ask this listing agent, who they found was posting it on open house on the MLS, and then they're going to ask the listing agent to help them write and prepare that offer. Just like in the 20, 30, 20 years I've been in the business, okay, a listing agent still holds a very near and dear primary fiduciary to their seller. Yes or no? We do know that their job is to get it sold, get it under contract with agreeable terms to the seller, and hopefully get their commission, get paid. So there's a great risk of these listing agents still appeasing the buyers to write up the offer, whether there is or is not compensation. That's up to that listing agent. But most listing agents that I would ask of you, I wouldn't want you to working for free. I don't want you to keep writing an offer for someone for 0 with no consideration or compensation. So your broker, and this is industry wide, all brokers are going to want, you're going to commit yourself to represent a buyer. Even if you're in a dual agent situation, you better get your fair share. And I'm going to have to teach you how to defend that fair share or incorporate it into the agreement. Because it doesn't mean that the whole buyer's agent is being removed. All that's going to happen is the buyer's agent needs to justify their own commissions and set their own terms and rate that is fully negotiated by that exact client. The whole practice of, since I've been in the industry in 2005, the whole practice is that a listing agent is going and doing the job of 2 negotiations. A listing agent would be asking for 5 or 6% from the seller, and to be advertised half of that maybe is shared on the MLS. So in theory, this listing agent like myself is asking the seller and I'm negotiating for a buyer to get a buyer's agent to get paid. I am. In our practice, that technically is a situation where this buyer who I have no idea is going to buy it when I take the listing, that buyer never got a chance to negotiate what rate that their agent is getting paid. So in technicality reasons, that's the argument from the plaintiffs who are getting the settlement. But are the plaintiffs actually winning? The sellers of the world of America, they're not winning. They already won when at the time of sale. They got their paid. They got a net, probably got paid over asking, or in the last 3-5 years, all the sellers have probably have a nice considerable equity and built. And so yes, the sellers are the winners by paper. The only winners of this entire settlement agreement is who? The plaintiff's attorneys. Okay, the attorneys are the true only winners. Any dollars like the $680 million being given out, a vast majority will go to the attorneys, and only maybe a slight concession will actually go to a seller or as a concession or awarded awards. Michael.
Kelvin, do you feel, are you getting a sense that when one goes on to a listing appointment, that we can still have a conversation with the seller?
Yeah.
Would you be willing to pay 2%, 2.5% to a buyer's agent if you choose that client? And we enter it into our listing agreement the way we have it now, where we have a line item that says that we will offer X amount of commission. It says we'll put it in the MLS, that'll be taken out, obviously.
Yeah.
But do you get a sense that we can still have that conversation with the seller, and the buyer's agent commission can go into the listing contract? Cooperating agent could call us and make an inquiry, so they could tell their buyer how much they want their buyer to pay on a buyer agreement. So it will equal what the buyer's agent will work for. So
I think
so
in
there's
theory,
flexibility on both sides here. Listing agent could get a 1%. The buyer's agent finds out there's 1% on this home. So they discuss with their buyer, will you give me 1.5% on the buyer broker? We put it together, I get 2.5%.
Mhm.
Do you think this will still be legal to have it work out this way with the seller? And not on the MLS, you have to call it out.
so you are putting a good question forward. Is it possible for a listing agent to predetermine or pre-ask a seller? I know all commissions are negotiable, but are you willing to offer a compensation for a buyer's agent? I think you're allowed to ask that question
Put it in
and
the
to
contract.
prepare a seller to have expectations that offers that may come in through my efforts on the MLS. All the offers may indicate a request for commission to be paid by the seller. So yes, the answer is you could plant that seed that yes, to
We put it
expect
on the listing.
offers will have conditions or requests for compensation that are still negotiable.
We could put it
Okay.
in a listing contract if they agree to do it.
So if you're asking me an amount must be specified, I can't give you a yes or no,
So
but I can plant the seed, yes, there will be requests for a commission with attached conditions on those subsets, potential offers. So we have to stay tuned. All of this has shook the industry in less than a week. So the answer, I know you want answers today. Answers are not ready yet. Even the attorneys at the associations are not prepared to talk about this, but I'm prepared to talk to you about what I anticipate from my eyes as a broker and the things that I've read thus far. All it's really going to require again is, to me, there's good and bad. Okay. The pros of this, from our eyes as practitioners here in San Gabriel Valley, the advantage of that is I know a lot of agents who are just really reliant on being only a buyer broker, buyer agent. Because they know it's so easy just to show a home and write a contract and boom, they get paid 10, 20, $30,000. So yes, I do think this will make it harder for a lot of buyers agents because a lot of buyers agents are not comfortable in asking their client to pay them commission like 10, 20, $30,000. And imagine you having this discussion with your buyers. Hey, I need 2.5%, and they're shopping for $1 million home. So that's $25,000 buyer. You got to pay me for writing a piece of paper and taking you and showing you and opening these doors. To a buyer, that's going to sound like a lot of money. I don't know how strong you're comfortable at and asking them to justify the more things that you do as a buyer's agent to justify your $20,000, $30,000 that you want.
Well, this could have easily
Okay.
affect their loan as well when the lenders look at. how
Yeah,
much
yeah,
they're
I haven't gotten
not
to the
gonna
next.
be-
I'm not talking about the pros right now. And so the pros is a lot of these buyers agents will exit. It's already anticipated. Several 100,000 agents will exit by the end of this year because of this. Okay. And several 100,000 mortgage lenders have already exited because the rates were too high a couple years ago. Okay. And Martin knows that. Okay. A lot of lenders have left because you go where there's potential, where the rainbows, where there's a rainbow. You go where there's a boom, or people are going to make money, are not going to be able to justify how they earn the buyer's fee, or they're going to have to do it at a discounted rate. Okay, instead of earning 2.5 or 3%, maybe you have to learn how to live by doing it for 1.5 or 1 or even less. I'm not saying you should. I'm just telling you there always is going to be a discount broker somewhere in any market. So there will be discount agents out there that are limited services. I write offers only. I don't even show homes. Or I show homes, but I don't write any offers. Okay? Then it could be a limited service agreement. Okay? The cons, the pros of this is definitely gonna become the agents that do survive and adapt probably will thrive better because there's more volume and more business going to those who know how to educate their client and have a controlled conversation and explaining how the process will work. If you're good at explaining and just understanding that, you'll probably be okay. If you're a listing agent, you'll have a lot of control. You'll still have buyers. There's still short demand. I mean, there's still high demand, short supply. So a listing agent should be able to succeed in this new normal. Thirdly, the other last pro I can think of really, you're gonna be dealing with a lot more professionals. The people who are just doing 2 deals a year, or the part-time agents, the people that don't speak English well, they're not going to survive. So the people that are in the industry, you'll find deals and relationships ever so more important than ever. Okay. So if you have good relations, good partners, you know how to solve, you have a all-in-one concierge where you got a lender, title, insurance, you got everything in your back pocket, and all you have is solutions. The experienced realtors will prevail. Okay, those are the pros. The cons is manyfold. Okay, I can only think of 3 pros. The cons, when there's allowing commissions to be negotiated, the tendency of negotiation tends to have downward pressure on overall commissions. The pie and the size of number of buyers agents is anticipated to be 25 to 50% less. Just by allowing the buyer's agent fee to be negotiated. That's the anticipation. Okay. So for brokerages, that will mean less overall total commissions being generated and earned by every brokerage across every city out there. Okay. We're gonna have less of a pie to work with. Even though volume could slightly increase, that doesn't necessarily mean commissions will increase accordingly. So I think there's gonna be downward pressure on the rates. I do think there's gonna be a lot more dual agency. I think right now, dual agency is somewhere around 3% of MLS transactions. Expect that to rise and be greater than 3% in the new normal, mid-July. Okay? Because there'll be a lot more opportunities for buyers to just meet the listing agent because they're not liking any buyer broker agreement making them sign. They might just work out a deal directly with the seller. The other cons, this is really bad for the buyers, and it's going to probably make it much tougher for buyers to actually qualify and purchase a home. Because without offers of commission out there, buyers are now really are probably going to tend to rely, because they're going to be afraid of signing contracts with buyers agents. So more buyers will take the greater risk of going self-represented. And I'll figure it out myself. I'm a smart guy. Oh, I just graduated from college. I can read agreements. And they're going to try to negotiate their own deals and purchases without the services of an agent. Okay. That's a risk, but that's a detriment to the buyers. To the sellers, I also think there's some risk to that, because if a buyer has to pay their own fees, that will take away from their qualifying funds to qualify for that mortgage. So they're going to write more conservative or lower offers to the sellers that may end up being not as compared to the same net that they might get if there was a blanket overall offer of compensation. The MLS, the field of commissions will probably be removed entirely. I do not know if there's going to be an ability where an agent says a buyer's agent commission available, call for more details. Okay, and then maybe if they allow it, sure, it could be allowed. Or most agents will probably say something, submit your offers. Any agents requesting a commission to attach form ABCD, whatever it is. Okay, then follow that instruction. Okay, and I'm sure some agents, the good listing agents, will set the proper expectation with the sellers that they will be coming along and everything is going to be different and negotiable. So just allocate and budget aside. The other good thing for you guys as listing agents, I don't have to fight and ask for a full commission for someone else. So if you want to look at the bright side, I can go and get a commission signed for 2.5%, and I'm happy. I don't have to fight for someone else's 2.5%. My job is easier. Just my listing fee is this 3%. I'm going to do this and this and this for you, full service, great photography, staging, the works, all of it, you name it. And all you got to pay me is my 2.75%, Mr. Seller. And I don't know what the other one's rate, and we can even make it where we don't even pay anything out if that's what you prefer. But you're going to have to be able to educate the client what the pros and cons of advertising a property in the commission inside the MLS, if it's allowed. Okay. The other negative things about this is it's just really going to be, I feel, fiduciary duty in itself is going to have a lot of issues. Because if I'm a listing agent listing a property with the zero commission on the out there, I technically may or may not be doing my service to my client. Okay, what is that? What do I mean? Well, since I'm not able to advertise a good normal commission, like whatever 3% out or 2.5% to the buy side, okay, how do I price this property? Okay, do I include it with factoring commissions or without factoring commissions? I'm now having be forced to make a decision. Okay, so there's liability anytime an agent makes a decision. Okay, secondly, because it's setting the price is a decision with the seller. Secondly, there is liability in the fact that I'm a listing agent advertising zero. Okay, now then I have a whole bundle of agents of buyers coming in the unrepresented side. Now, let's say out of 50 people walking in my door, 25 are unrepresented, 20 are represented by an agent who signed whatever, and 5 might be, on the fence, or 5% might just be, I prepare to write. I'm a sophisticated buyer. I can write my own offers. Okay, great. I know how to deal with the agents, the buyers with agents. I know how to deal with a sharp, sophisticated investor. But in all the arena of the unrepresented buyers agents, I have to have a language. I have to have a commission discussion with every specific person 1 through 25? Yes or no, right? Out of those 25 people, hey, for you, I'm gonna have to charge you 2% if I write your offer. And guess what? I know I can make more money off this wealthy San Marino resident. With you, 3% of my services, I'll write the offer for you. And 2% for you guys, because you guys are a couple and you're struggling, but I want to help you guys because you guys are a family and 3 newborns. Whatever it is, I can do it for 1% for you guys. I want to see you guys get it. I'm stuck in a pickle of these people ganging up on me, and I'm charging different rates for the same damn transaction for the damn Sam service. Guess what happens to me as a broker? I'm scared of the decisions you're going to make because you're going to be giving different offers. I already know it. Some people are going to be greater at negotiating with you, and some people are going to be affording you to do it, and some people are going to be cheap and Chinese. Okay. I don't, whatever it is, between you and I'm telling you, these disparaging rates puts you in a, number one, potentially discriminatory actions. Number two, are you serving the best interests of the seller who you have that contract already signed, and now you're negotiating for yourself? That technically is a breach of my fiduciary when I'm negotiating for myself separately. So who's going to be able to handle all of this professionally, ethically? Even myself, I'm afraid to do that. But then again, a vast majority of agents are going to leave, and the vast majority of the listing agents still want to earn extra income, and they're going to learn how to adapt and find ways to extract that commission. I just don't know how ethical every agent is going to be. And just like at any time or period, even in the new normal, when the bad agents left, there's still going to be a bunch of unethical agents who find a way and a strategy to extract that legally. All right. I'm not telling you how it's going to happen or work, but I'm telling you those are the risks that I foresee. All right, now Nancy, go ahead.
I've talked to a couple of really good professional listing agents, and I asked for their opinion, and now we can't even put 0 in their docs. We can't put any number.
It's not gonna be, I don't think it's gonna be anything.
Yeah, it's gonna be probably that default is gonna go away.
Mhm.
Okay, but the listing agents, the good professionals, they say, well, I also sometimes deal with buyers, so I want to earn that commission.
Yeah.
So the form, the buyer's representation and broker compensation agreement, they were working on it, and this is their current idea of how to handle it. If I'm a good listing agent, I will ask the buyer's agent that's coming to me to say, you better get that signed. And I'm still gonna give you 2%. Because they don't wanna deal with what you just talked about.
Mhm.
You know, it's a conflict of interest. Do I help my buyer or help my seller? My commitment is my seller. So they're still gonna negotiate at least 4 to 5% commission with the seller, because that's the norm. It's not legally, it's negotiable.
Mhm.
But they're saying if the buyer's agent better come with that and ask for it.
Mhm.
The buyer's representation, for local compensation for it, the buyer's agent should have it.
Yeah.
And send it to them with the offer.
Yeah.
So they can deal with it in a rational and a legal manner, because that form's been there for 30 years,
Yeah, there's already a checkbox now in
Right.
your purchase contract
right?
to attach your agreement with your buyers to be incorporated in the contract, which is what you want.
Yeah.
Because if you want it paid at escrow at closing, the escrow has to follow the contract. And if you have a separate agreement with your buyer and you say, I have an agreement, it's text message with my buyer, whatever I sell them is 3%. That's not held or bound by the seller. Your text. So if you want to bind anything with your agreement between your client, bind it in the contract with that checkbox of the buyer broker agreement, which is already now in the RPA. Michael.
NAR has announced that they're going to make the buyer broker documents mandatory for all buyer's agents.
Yeah.
And that'll make it easier to discuss that with the buyer, that it is a mandatory document.
It's a mandatory form, but Michael, the agency disclosure is a mandatory form upon your first showing with the client. How many times have you shown a property to a buyer without that agency disclosure? Many times. So just because something is mandatory doesn't mean everyone will follow it. Just because there's a red light or a green light doesn't mean everyone's gonna follow the signs.
Well, for us to discuss it with the buyer.
Yeah,
Letting them know that this is a mandatory document, we have to work on this. I think it'll be helpful when it becomes mandatory, it'll be. make it
Correct.
A little bit.
it'll just have to educate the client a lot more and have an extra conversation regarding commissions and how the whole system is gonna be working. And Martin,
One of the things that we on the lending side have been talking about is when we do a loan for buyers and they have an agreement with the buyer's agent for 2.5%. And let's say the seller won't give them the money, then we as the lender have to figure out, okay, does the buyer have the money for this other legal obligation, just like they have a regular car loan payment or other mortgage? Do they have the cash required to pay this buyer's agent out of their own pocket? And if they don't, that could potentially be a lien, potentially.
Yeah.
In the future that the lender has to worry about.
Yeah.
Now, whether or not that could be a lien on the property, I don't even know yet if that would be allowed. If they go to court and they could put a lien on, anyway, those are things that we've been thinking about, like, okay, we gotta make sure that are the lenders gonna require the buyers to show proof of ability to pay the buyer's commission?
Yeah.
If they wind up having to pay it, and if they can't, would that be a reason to sort of deny the loan?
well, yeah, it's gonna have definitely many repercussions that policymakers did not think about. Because policymakers don't practice what we do.
And we're trying to lower the cost of housing for the buyer, but at the same time, now they're gonna be forced to pay more. It's none of it makes sense, so then the lawyer,
So at the end of the day, we're a multi-billion industry. They know NAR has a war chest of funds to fight political advocacy. And in this situation, this is attorneys and sellers seeking where the targets are and prevailing with the settlement. And so that is now forcing us to adapt. But that's my general take on what to expect. I don't fear too much about you guys not being able to justify and explain what you're worth, but it's just sad that I have to report to you. It probably will lead to more problems, more learning, more education, and honestly, you becoming stronger negotiators. Okay, it's gonna have to force you to be better. Okay, to have stronger, meaningful explanations and educational explanations on commissions.
Maybe after it's all said and done, the new normal will be buyer's agents get 3 or 4%. Everybody figures out how much they actually do.
It could be better.
And how much they're worth.
Yeah, it could be, you could be valued a lot more work.
Not all
Anyone else have any comments or questions regarding NAR, DOJ, or my opinions or speculations about what the industry is gonna feel?
But the buy representation, this form.
Yeah.
Is not exclusive, so the buyer can.
You can make it exclusive.
can sign with other.
It is a valid legal contract. It is considered, if you check it to be exclusive, you could. The problem, if this buyer violates and breaches your agreement and signs with listing agent number, whatever, of the property that they liked, because you were, again, they circumvented you, you're finding out after the fact. We, as a broker industry, an agent that's impacted, we would have to pursue it through small claims or through arbitration or a complaint. So we would have to file and sue to get that contract enforced. Okay, so that now would add a layer of, yeah, I can win 15,000, but if I gotta lose 10,000 in fees and 6 to 9 months of time, is it worth it to earn the net 5,000? That's the question that's gonna suck for a lot of us. So anyways, if you're signing listing contracts, if you're having these discussions, talk to me about how to, I'll prepare something more informal so you can share with your sellers So that way you're equipped with how to handle these situations questions that you're gonna come up with. Nancy?
Yeah, I think that the consumer that we're dealing with, especially by, they're not educated how difficult, how many laws, how many problems. And legal facts of what you do for them, how much you help them. So I think if you have a buyer, educating them first, because they're gonna ask you this question right now because of the legal.
Yeah.
If you don't have the answers, you're not gonna be able to get any. You gotta help protect themselves and how difficult it is, give them the information, show them forms, show them on the.
Yep.
Termite, inspection, all that problem can cost them a lot of money.
Mhm.
And you're there to protect their nesting and their investment. It's difficult, it's gonna be difficult, it's gonna wipe out a lot of the. Like you said, the party admins and details of the.
It will.
We already had a client call us from Taiwan and say, and they got the news over there.
Yeah.
And saying, well, if I don't have to pay a buyer's agent anymore,
Yeah.
right? And then Michelle wanted to come here, so she knows how to respond to that, because it's one of our. past
So
clients.
anyone who thinks that a seller does not have to think that they don't have to buy a buyer's agent, all you can say is, well, seller, the media is pointing it
That's what's
in
on the media.
one aspect. Yes, it's not just true, it's partially true. A seller does not need or does not require to advertise compensation, but in reality, the buyers out there want representation, protection, and want to get your property. But at the same time, realtors don't write offers for free. And they do take time to open the doors because you do not want a public buyer opening your door and getting access to your property. You want a licensed professional who has to bound by the code of ethics to be accompanying a client through and getting them through the process and vetting them out with their qualifications with the lender, getting a pre-approval. You want to have vetted buyers, not just random, homeless people who could be coming through your home if you want to try to work with them directly. Okay, so in the end, sellers may still have to end up paying some form of buyer broker commission because offers are going to be including a request for it. Okay, that's still how it's going to be.
We'll be fighting the media for a while.
Well, the media is not there to tell the truth.
Right.
The media is out there to get clicks.
Oh, buyers don't get.
Okay.
paid anymore. Buyers
These-
agents-
The whole thing is media is out there just is designed just for them to get an audience, just to hear them. They don't have to tell the truth. Okay, so media is not the best source of information. Okay, anyway, that's it for everyone for today. Thanks for coming. Thanks, Ramona, for being here this whole time. I'll see you next time, okay?
The attorney was really great.